When a sitting U.S. president walks into the Supreme Court to watch arguments in person, that alone becomes a major story. But on April 1st, this was about more than symbolism. President Donald Trump appeared at the court as justices examined one of the most consequential legal questions in American public life right now: whether his administration can restrict birthright citizenship through executive action. According to Reuters, Trump became the first sitting president to attend a Supreme Court oral argument, and the justices, including several conservatives, signaled skepticism toward the legal basis of his order. To be clear from the start, the core event here is fully verified and current. The hearing took place on April 1st. Trump's attendance was confirmed in advance on March 31st and then documented during the hearing itself. The policy at issue remains blocked for now, and no final ruling has been issued yet. What happened today is not the end of the case. It is the most visible and politically charged moment in it so far. So what exactly is being argued? At the center of the case is Trump's executive order, signed on the first day of his second term, directing U.S. agencies not to recognize citizenship for certain children born in the United States if their parents are neither U.S. citizens nor lawful permanent residents. That would mark a major shift from the long-established understanding of the 14th Amendment, which has broadly been read to guarantee citizenship to people born on U.S. soil, with narrow exceptions such as children of diplomats. That constitutional language matters. The Citizenship Clause of the 14th Amendment says, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." The Trump administration argues that this clause does not automatically cover children born to people in the country unlawfully, or in some cases, temporarily. Challengers say that reading conflicts with more than a century of constitutional understanding and with Supreme Court precedent, especially the 1898 case United States versus Wong Kim Ark. That is the legal backdrop. But what made this hearing especially notable in the last 24 hours was the combination of law, politics, and presidential theater. Reuters reported on March 31st that Trump said he would personally go to the Supreme Court, and later the White House confirmed his attendance. Then, on April 1st, he arrived at the court, sat in the public gallery during the arguments, and left after the government's lawyer had presented the administration's case. That sequence is recent, specific, and confirmed, and the arguments themselves appear to have mattered more than the optics. According to Reuters, AP, and The Guardian, justices from across the ideological spectrum pressed the administration on both the logic and the practical consequences of its position. Chief Justice John Roberts questioned how the government could expand a historically narrow exception into a much broader rule. Justice Elena Kagan said the administration seemed to be relying on obscure sources. Justice Neil Gorsuch raised doubts about how the administration's theory could fit with existing precedent. That does not mean the final ruling is known. It only means that, during oral argument, the administration encountered serious questions. Oral arguments can signal concern, but they do not always predict the result. This is one of the most important distinctions in covering a live legal story responsibly. What is confirmed is skepticism in the courtroom. What is not confirmed is how each justice will vote when the decision is issued. Reuters says a ruling is expected by the end of June, while AP says early summer. To understand why this case matters, it helps to slow down and look at the stakes beyond the courtroom. AP reports that more than 250,000 babies born in the United States each year could be affected by the executive order. Importantly, AP notes that the restrictions, if upheld, would not apply only to people in the country illegally. They could also affect some people who are legally in the United States, including students and applicants for green cards. That practical impact became a central theme during the hearing. Reuters reported that several justices pressed the government on how such a system would actually work. How would officials determine a parent's legal status at the moment of birth? How would they handle cases involving unknown parents, temporary visitors, or families whose immigration status changes over time? Those questions are not abstract. They go to the administrative reality of enforcing a citizenship rule at birth. The administration side, presented by Solicitor General D. Sauer, argued that automatic birthright citizenship has been interpreted too broadly and that the constitutional phrase, "subject to the jurisdiction thereof," should be read more narrowly. Reuters reported that Sauer said broad birthright citizenship demeans the priceless and profound gift of American citizenship and acts as a pull factor for illegal immigration. The Guardian said he also leaned heavily on the concept of domicile. arguing that people in the country unlawfully or temporarily do not have the kind of lasting allegiance that the amendment was meant to cover. The challengers answered that this interpretation would radically rewrite settled law. According to Reuters and The Guardian, lawyer Cecilia Wang argued that Americans have long understood a simple rule: if you are born here, you are a citizen. She told the court that the 14th Amendment placed that rule beyond the reach of ordinary political officials. The Guardian also reported that the challengers warned Trump's theory could place the citizenship status of not only future children, but potentially millions of Americans under a cloud of uncertainty if the constitutional meaning were reopened in a broad way. There is also the political context. Birthright citizenship has become one of Trump's signature immigration targets. Reuters and AP both described the order as part of a broader immigration crackdown since his return to office. So this hearing is not just a technical legal dispute. It is a test of whether one of the administration's most ambitious immigration moves can survive judicial scrutiny. That helps explain why Trump chose to attend personally and why the case is drawing so much national and international attention. Still, it is important not to overstate what today means. The court did not strike the order down today. It did not uphold it either. The hearing itself is the development. The questions from the bench are significant, but they are not a verdict. Responsible coverage has to resist turning courtroom tone into a definitive forecast. So let's separate the story into three clear parts: what is confirmed, what is claimed, and what remains unresolved. What is confirmed is this: the Supreme Court heard arguments on April 1st on Trump's effort to restrict birthright citizenship. Trump attended in person, making history as the first sitting president known to do so for oral arguments. Lower courts have already blocked the order, so it has not taken effect anywhere in the country. Multiple justices, conservative and liberal, raised serious questions about the administration's theory and about how it could be implemented in practice. What is claimed is this: the administration says the 14th Amendment has been misread for generations, and that children born in the United States are not automatically citizens if their parents lack the right kind of legal status or permanent connection to the country. The administration says the constitutional text, properly interpreted, supports that narrower view. What remains unresolved is this: whether a majority of the court will accept any part of that argument, whether the court will rely heavily on precedent from Wong Kim Ark, and whether the justices could issue a narrow ruling on procedure or scope, rather than a sweeping answer on the constitutional merits. Those are open questions today. None should be presented as settled fact. There is another reason this story is resonating beyond legal circles. Birthright citizenship is not just a constitutional doctrine. It shapes national identity, immigration policy, federal record-keeping, and the legal status of families at the moment a child is born. That is why questions from the bench about paperwork, domicile, intent to remain, and proof of parental status drew so much attention. These are the kinds of details that can sound technical until you realize they would affect birth certificates, citizenship recognition, and access to rights from the very beginning of a child's life. The hearing also highlighted a deeper tension between constitutional continuity and political change. The Guardian reported that Roberts responded to the administration's attempt to update the doctrine for a new world by saying, in essence, that while the world may be new, the Constitution remains the same. Whether or not one agrees with either side, that exchange captured the basic challenge before the court. Should modern immigration pressures alter the long-standing interpretation of an amendment written in the aftermath of the Civil War? And then there is Trump's own role in shaping the narrative. His appearance at the court placed the presidency physically inside a constitutional confrontation over one of his signature policies. Reuters noted that he later posted on social media, criticizing birthright citizenship itself. But again, the fact of his political commitment to the issue is separate from the legal question the justices must answer. The court is not being asked whether the policy is politically popular. It is being asked whether it is constitutionally permitted. As of now, the current situation is relatively clear. The executive order remains blocked. The justices have heard the arguments. Both sides have presented sharply different views of the 14th Amendment, and observers are now waiting for a decision expected later this year. No immediate operational change has been reported. No new enforcement regime has begun. Families affected by the potential order are still in the same legal position they were before the hearing started today. So, what should viewers take away from this story tonight? First, this is a real and current development, not a recycled political talking point. The hearing happened today, within the last 24 hours, and it addresses an order that would alter a long-standing understanding of citizenship if upheld. Second, the legal challenge appears serious. Multiple outlets reported pointed skepticism from the bench, including from justices not usually grouped together politically. That does not settle the case, but it does show the administration faced substantial scrutiny. Third, the stakes are not symbolic. According to AP, the order could affect more than 250,000 babies a year, including some born to people who are legally in the country. That is why this case matters well beyond partisan politics. And finally, the most responsible conclusion right now is a limited one. The court has heard the argument, not issued the final word. Trump made a rare and historic appearance. The justices raised doubts. The policy remains blocked. The constitutional question remains open until the ruling arrives. That is where the story stands at this moment. That makes this one of the most consequential U.S. legal stories of the last 72 hours, not because of a final decision, but because the Supreme Court has now openly confronted a direct challenge to one of the country's most established citizenship principles, with the sitting president watching from the room.